My name is Jed Stabler. I'm a partner in the law office of Stabler and Baldwin. I concentrate my legal practice in the area of estate planning, including probate administration and the administration of trusts. I've been practicing here in South Florida for approximately 15 years now. Having started my firm back in 1999 here in the West Palm Beach area. We provide legal services all over South Florida, Palm Beach County, and the state of Florida. Probate is the legal process by which a will gets submitted to the court. The judge signs an order validating the will, signs an order appointing the personal representative, and distribution is ultimately made to the beneficiaries. Probate is time-consuming, it's expensive. On average here in Florida, it takes anywhere from 9 to 16 months on average to probate an estate. And by statute, 3% of the gross value of the estate and the income is considered a reasonable fee for attorneys when probating an estate. And not to mention the fee that would otherwise be paid to the personal representative of the estate, and the filing fees, the costs associated with filing the probate and publishing, what's called a notice to creditors, which is the notice requirement here in Florida. And we're required to publish a notice to creditors. So, the advantages of avoiding probate is you avoid the expense, is a biggie, and of course the time and the headache involved. One of the biggest misconceptions is that a will avoids probate, and in reality it's the exact opposite. A will doesn't avoid probate. A will requires probate. Most people think person passes away, the named personal representative or the executor, bounces into the estate, bounces into the bank, for example, holds the will up, presents a death certificate, and says, "Here I am. I'm the personal representative. Do me a favor, give me all the assets so that I can distribute them to the beneficiaries." When in fact, a will, before it even becomes valid, must be submitted to the court. The judge has to sign an order establishing that that's a valid will. The named personal representative or executor, as they're known up north, doesn't get appointed until the judge signs an order saying that appointing that personal representative, assuming they qualify. So a will does not avoid probate. It necessitates it, because unlike that revocable trust agreement, a will must be submitted to the court to be valid. The legal process by which a will gets submitted to the court, the judge is going to sign an order validating that will, admitting it to probate, signs an order appointing that personal representative, and then that is really the first step in that probate process. There are a number of different ways that people use to avoid probate. One of the most popular ways is simply by holding assets jointly with the co-owner. Clients come to me all the time. They say, "Boy, Jed, I've done a great thing. I've added my children's names to my assets to avoid probate." But really, it's one of the most dangerous things that you can do. And that is because of creditors. If you run out and you add your son or daughter's name onto an asset or an account as a joint owner, yes, when you pass away, that property, that asset is going to pass by operation of law directly to that joint owner. But the problem is that of creditors. If your son or your daughter, God forbid, were to get into an accident or be forced into bankruptcy, because their name is on your asset as a joint owner, their creditor could potentially get to your asset. So although it's a very common technique that people sometimes use to avoid probate is really one of the most dangerous techniques that people use. Another way to avoid probate is simply by designating a beneficiary. You've heard of POD accounts or in trust for accounts where a person sets up a bank account and names children, for example, as beneficiaries, right? POD, payable on death, or in trust for, right? ITF, in trust for, right? Essentially what you're doing is you're naming somebody as a beneficiary on the account. The difficulty is that if your beneficiary who you've named predeceases you, then that asset is out there in your name alone, and again, you're back to probate. The other problem that people tend to run into when they name beneficiaries on bank accounts is that in a will or in a trust, you may say, for example, to my children in equal weight and equal shares, but if one of my children predeceases, I want his or her share to go to his or her children. We use a Latin term for that, per stirpes. It means lineal descendant. So, to the children in equal shares, but if one of them predeceases, the deceased child's share goes to his or her descendants. Well, if you had a bank account set up, POD, and you name the children, if one of the children should pass away, it's likely that that asset, instead of going to the deceased child's children, right, the grandchildren, it's likely that that asset is going to go back to your other child, which is fine if that's what your intentions are. But if in your will or in your trust you have it going to the children per stirpes, you can see how that could frustrate your intent. Thank you for joining us today and watching our video. I hope you've learned a little bit about what we do and revocable trust agreements and probate. Please feel free to contact the firm either via telephone at 561-471-7100 or through our website at jedastablerpa.com.